And now a few items from our Freedom Files. It's the story that no one else is reporting, but you can always count on your night watchman to bring you the stories others are afraid to cover. Earlier this week, the president signed the National Defense Authorization Act. If you've been watching our program, then you know that this new law authorizes the president to arrest anyone, anywhere, including on American soil, and hold the person indefinitely, including American citizens. President Obama once threatened to veto this bill, but not for the reasons you might think. The president's lawyers argued he already had this power. He also issued a so-called signing statement on this law, a practice he condemned when he was a candidate, claiming that the executive branch has broad authority to determine how it would like to implement the law. President Obama already kills Americans with drones. Now he has the power to round up Americans and ship them off to Cuba, never to be heard or seen from again. Happy New Year, America. Does the Fourth Amendment still exist? Police in the state of Florida routinely use a practice that sends canine teams out to sniff at the doors of homes without search warrants. If the dog scratches in front of the door, the police claim that that means the dog smells drugs inside. And then the police go to a judge and get a search warrant based on the dog's scratching. This is, of course, absurd. An unauthorized search has already taken place when the police dog sniffed for the drugs at the front door. Florida Supreme Court has rightly rebuked this practice, ruling that it violates the Fourth Amendment, which prohibits unwarranted searches and seizures. The U.S. Supreme Court may bizarrely disagree. The U.S. Supreme Court has ruled that police can enter your home just because what they thought they smelled. The Supreme Court will now decide whether to take up the Florida case, and Freedom Watch will keep you updated. This is a real horror story. 37-year-old Tina Funderburk of Brooklyn, New York, has spent much of the last 8 years in a Hinds County jail in Mississippi. She was charged with the death of her 3-year-old daughter, but is yet to be tried and may never be tried. What happened? Ms. Funderburk is diagnosed as a paranoid schizophrenic and has been repeatedly declared mentally incompetent to stand trial. She's stuck in jail until doctors can agree and a judge declares that she's either legally insane or legally fit to stand trial. The Hinds County District Attorney Robert Smith defends this abomination by claiming he has an ethical duty, an ethical obligation to make sure that we're prosecuting someone who is competent to stand trial. What about the constitutional guarantee of a speedy trial? After nearly a decade behind bars, it makes us wonder if the authorities have already decided it's her fate to spend another decade behind bars rather than get a real jury trial. Maybe they don't have enough evidence to convict her.